talk a little bit about the two federal, the federal and the state lawsuits, the Colas and the Conway issues? Just summarize a little bit.
Yeah, well, the federal lawsuits are pretty much done. It's extremely, let me tell you this, that is a very, very complicated area of the law when you get into equal protection, 14th Amendment, First Amendment rights, those kinds of things. They're very complicated. Most people reading those cases would not understand them. I could tell you that I didn't understand reading them the first time over. I would have to read them a couple of times to really feel like I understand them. So I'm telling you, they're very complicated. You should understand that law in general is pretty complicated in that you could take the very same word and have it in the state constitution, have it in the federal constitution, and you might have the federal judiciary interpret that word one way, and you might have the state judiciary interpreting it another way. So the results could be very different, because when you get into some of these complicated concepts, people have different opinions. And they could be totally honest and legitimate in their opinions and come up with different opinions. It happens in this room. People talk about something. They're all trying to do good, come up with the right answer, but they don't agree what the right answer is. So what happened in the state system is that Judge Colas in Dane County ruled that there was a violation of equal protection in the way they were handling recertifications and the votes on recertification. And he looked at it as a freedom of association issue, that they were interfering with people's ability to form associations. And he ruled that the state was violating the Constitution in that regard. The federal rulings have been different, and I would say that you may have gotten different arguments, there may have been a different slant to it, but right now the state ruling is different than what the federal ruling is. Judge Colas also said that the prohibition against collective bargaining in the public sector was a violation of the Constitution. So right now, he has told the state that it cannot conduct these elections. And he has also said that in the, and this is all in the municipal area, by the way, Colas's decision is dealing with municipal employees, not state employees. The federal one was dealing with state employees as well. Okay? So Colas issued that ruling. When he issued that ruling, I started bargaining in school districts, and we've been bargaining. We actually got a contract. All right? And we got it because that was the state of the law. In the state sector, nothing's changed, because part of it is, even when there was an obligation to bargain, and the law was absolutely clear, Walker interfered with it and didn't bargain. He didn't bargain when they changed the law and said you could only bargain about the cost of living increase. Why don't you check out where he's bargained? Virtually nowhere. And where he's bargained, he hasn't agreed to anything. Even with the limitation that you could only bargain about a cost of living increase, and even where he could determine what that cost of living increase is, or what's the official cost of living increase. Well, the WERC, run by two people that he appointed, determines what that is. So he's got the whole thing rigged. And even with the whole thing rigged, he can't reach an agreement. He can't sit down and say, okay, the least you could give let's say, is 0. And the most you could give is a cost of living increase that your people have indicated what it is. Let's say it's 2%. And even bargaining between 0 and 2%, that guy can't reach an agreement. And you know why? Because he doesn't want to. It's not his intention to reach any agreement. He doesn't want to bargain. He doesn't believe in it. He believes that if you have the power and you have the hammer, you don't need anything else. And so that's the way he operates. And people got to decide whether they want to live with that. And I can tell you, there are a lot of ways not to live with that. My personal opinion is that everybody who works for the state should come in an hour early and picket for an hour around their building before they go into work. And they would get everybody's attention. And there would be some excitement about that. And you wouldn't be doing anything illegal. But you know what? So far, there is no critical mass to go do that. So you get what you get. You know, if you want to tolerate stuff, you tolerate it. But that's where it stands. Now, I want to say one more thing about the Colas decision. The way the law works is this, that if a circuit court issues a decision, now that's the lowest level, that's our trial court, and it's the lowest level of our judiciary. When a circuit court issues a decision, that's the decision. That's the law. Whether they are right, wrong, or otherwise, that is the law. You are required to follow it. Unless you ask for a stay pending appeal. Okay, so you say, Judge, leave this thing alone as it was and give us a chance to appeal. So until we appeal, you're saying things are going to stay the way they were before I issued my decision. Now, a judge does not have to give you a stay. They can do it, or they can not do it. You can also go and ask for a stay from an appellate court. You can go ask the Court of Appeals to stay the lower court's decision. But you have to get a stay. And if you don't get a stay, then the lower court's decision stands until it is overturned. Unless and until it is overturned. So, you know, there are people who just don't appreciate that. So I get the school district where I negotiated a settlement, a contract a year ago. We go on to negotiate again. And they say, well, the law is in a state of uncertainty. It is and it isn't. It isn't because there's a court decision that's not uncertain and unclear. It's darn clear. You just don't like it. So then what you got to do is ask for a stay, and it goes back to the way you liked it, or you wait till you appeal. But right now, this is the law. And what happens is a lot of people don't really know how that works. So you get this gobbledygook about things are unclear, we don't know what to do. You know, just do what you're supposed to do. And everything will be fine. So you have these two tracks going on. In the state area, I can tell you that there's nothing happening much that's going to, I wouldn't look to the law, meaning the court system, to effectuate much of a change on where things are at. My personal opinion is that employees, workers, need to do that. If they think somebody's going to do it for them, just wrong, and they need to do something. In my opinion, everybody should have walked out when they were considering this thing, and they shouldn't have let it happen. Once it's happened, it's harder to reverse. But workers could still make their voices heard if they organize, back their organizations, and take actions that are lawful but strong, and make it clear that they won't tolerate the kind of treatment that they're getting. And you could go into work and ask around, and you're going to find there are a lot of people not talking about the way they're being put upon. And then there's some that are. People are afraid, and they don't even talk about what's happening to them. So I don't think it's going to get better as this administration stays on and on. And I think it's going to be hard to reverse once they leave. Because even if you get a Democratic governor, if you have a Republican legislature, nothing's going to change. The only thing that's going to change is you might get a change in administrators and people who are running agencies, and they might be somewhat nicer. But people who get into power and have authority tend to want to exercise it the way they want to exercise it. And that's not necessarily that Democrats are better than Republicans or Republicans are better. People are people.